Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
So, Emma, I just want to just flesh out a few more things that we covered briefly. And one of those is if a person wants to leave an estate to particular individuals, maybe it's a percentage or whatever they decide to do, what's the best method of doing that?
It effectively depends on what a person's wanting to do. I mean, there's the option to leave a specific sum of money. So say if there's a desire to benefit 4 people from the estate, you could figure out what the overall estate assets are, which some people do, and leave a specific sum of money. So if it's an $800,000 estate and they're wanting it split equally, they could effectively provide that they leave $200,000 to each beneficiary. However, the issue with that is that estates often fluctuate. So the value of an estate often fluctuates. So the value might be at the time a person does their will doesn't necessarily mean that that's going to stay the same when their estate's actually administered. So sometimes a more effective way to do that is to leave a percentage of the residue. So leave a residuary gift, but do it in percentages to beneficiaries, because that way, if the assets of the estate go down, that particular gift or the value of that gift also will go down. And if it goes up, then correspondingly, the value that person receives will go up. So one of the situations that I've seen in the past, which has caused some difficulty, is that when someone prepared their will, say their estate was worth $1 million, they wanted to leave effectively a half of that, but a $500,000 gift to a particular person, and then the rest of their estate to another person. And when they prepared their will, because part of my role is actually administer estates, so I have to administer wills that are prepared elsewhere too. But when it actually came time to administer the estate, the value of the estate had fallen. So the value of the estate in this case was around $600,000. The problem that you have is when you're actually administering estates is that pecuniary legacies are paid first. So because there was a gift of $500,000 in that will, that's actually paid first, and then the residue passes to that residuary beneficiary named in the will. So in that case, there was a bit of an unintended consequence of that one beneficiary got $500,000, but the other one only got $100,000, when it had probably been that testator's intention that they both benefit equally from the estate. A way that probably could have been dealt with is if that residuary estate was just left equally to those 2 beneficiaries, because that would have meant that they each would have got half of the total estate. So that they both would have got $300,000 rather than have this inequity in what was effectively distributed. So it really depends on what the intentions are of that will maker as well. There are some benefits that if a testator is really wanting someone, and I use that term testator, it's will maker, it's a bit of an interchangeable term, but if there is a fixed view that they're only wanting a person to have a specific sum of money, irrespective of what the value of the estate is, then by all means you can provide a fixed amount in there or pecuniary legacy. But if the intention is that they're wanting multiple people to benefit from their estate, equally or in certain proportions, then actually specifying those proportions in the will can be quite beneficial.
Great. Okay, that helps a lot. And something else we've touched on briefly and it'll be worth fleshing out is that I guess there are some important things to be aware of when you want to leave charitable requests in the will as well.
That's right, Tony. It's actually quite an important issue is when a person might want to benefit a charity. So there's a few things around that, and as I mentioned, is a lot of my job is actually administering estates. So unfortunately, I see what happens when things go wrong. So I've got a few war stories about that. But one of the most important things is, and it seems quite basic, but it is an issue, is making sure that the charity that the person wants to benefit is actually correctly identified in the will. So quite often with charities, there might be different arms of a charity. So there might be, a particular charity, but they have a few different arms. So there's a few different business names and they do a few different things. So it's really important to identify that correct entity who's authorised or who would usually receive that charitable bequest. And as I touched upon earlier, that's important for a number of reasons, because it's usually that entity that will have the favourable taxation status, that would be registered with the charity, with the ACNC, which might have that deductible gift recipient status. So effectively the tax benefits that go along with that. So it's really important that when you're crafting a will, that you correctly identify that charity. And often what that means is actually reaching out to that charity. And more often than not, they will have information available on a website, which clearly identifies that business name, the ABN, and really identifies that charity.
Yeah, exactly right. I'm aware that there's been a few issues about having the wrong ABN number, but the correct name and all sorts of fun things. So, best of luck.
And it can be a bit of an issue too, Tony, because if there is actually an entity, an entity named, and I have a bit of a situation at the moment where there's a charity named, but the charity that's named, it's under the same umbrella, but it's the charity, it's the arm of the charity that doesn't have the taxation status. But there's been a bit of an issue with the ABN, and the ABN's actually very similar to the arm of the charity that does have the taxation status. So what it effectively comes down to is that the name, the name of the charity mentioned in the will doesn't even match the ABN that's mentioned in the will. So one of the important things is really identifying that, because there's I suppose a bit of work involved in trying to resolve that, because at the end of the day, what people want to ensure is that they actually put into effect what the will maker wanted and are able to give effect to that. So just basic things, well, it may appear to be basic, but there is a bit in it, but just making sure that those entities are clearly identified, that they're correct, and also stipulating the purpose which a person might want to leave funds to, and whether that's actually achievable for that charity. So more often than not, charities might not be equipped to deal with what we call specific gifts. So if someone has a fabulous collection of artwork that they want to leave to a charity, it may be the case that charity is not really equipped to deal with that particular gift. And there have been cases where charities have actually had to, unfortunately, disclaim or refuse gifts because they can't be utilised by their particular organisation. So having that discussion early on when you're crafting the will is often quite beneficial. So it makes sure that what the person wants is able to actually be facilitated and achieved, so to speak.
Yeah. Life is complex.
It is. And unfortunately, it's one of those things that there are no easy answers. And it's, as I mentioned, it's certainly not a one-size-fits-all approach in an estate plan. It really does need to be carefully crafted and tailored to a particular individual circumstance. I suppose one of the issues we've also spoken about is the importance of being aware of identifying correctly charities when there's a desire to give a charitable donation. So probably one of the key takeaways to consider when developing an estate plan which involves gifts to charities is liaising with those particular charities to make sure that they're correctly identified in the will as a start, and also the subject matter of the gift which is wanting to be given to those charities can actually be achieved. So again, estate plan shouldn't be created in isolation. There does need to be a level of consultation had with particular charities. And it's just imperative that that's done to ensure that a person's wishes are actually given effect to and able to be given effect to and achieved.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.